Hi, good evening. My name is Elena Booth, and I'm gonna be actually your moderator this evening. We're truly excited. We have Judge Anderson here. I'm gonna allow him in a few minutes to be able to give some time to be able to tell you all a lot about himself. We bring greetings from the Baton Rouge branch of the NAACP. We are also in partnership with the Louis A. Martinet Society here. We bring greetings also from our president of the Louisiana State Conference, Mike McClanahan, and also Eugene Collins. Again, my name is Elena Booth. I am the Social Justice Chair of the Baton Rouge branch of NAACP, and I also am the Director of Equity, Diversity, Inclusion for Baton Rouge Office of Public Defender. We have an extremely excited and amazing night where you all are going to hear from several judges who are running right here in Baton Rouge. Judges have so much power, so please listen to their platforms. We are going to start by giving Judge Anderson a 5 minutes to be able to introduce himself and also for you all to be able to hear a little bit about him. After that, we're going to go through a series of questions, and each judge will be able to have 2 to 3 minutes to be able to answer. We are actually going to conclude with Judge Anderson at 6:30, and we are going to start with the next race at that time. But at this time, I would also say thank you, Judge Anderson, for being here. I am thanking you from the NAACP and also from the Louis A. Martinet Society. We understand you could have been a lot of different places. We understand you have an extremely busy schedule. So we appreciate you taking out the time to be with us tonight and also for you to be able to have a voice with the community and for you to tell us a good bit about yourself. I'm going to give you 5 minutes to be able to tell the community who you are and what you stand for.
All right. Well, thanks for having me tonight. I really appreciate the opportunity to tell people a little bit about me. Um, I'm from Baton Rouge. I've been here all my life. I'm 64 years old. I've been a district court judge now for almost 24 years. I've been married 42 years. I have 3 sons, 8 grandchildren, and another one on the way. All of them live here in Baton Rouge, so I have a vested interest in Baton Rouge and in this whole community. I graduated from Estruma High School in 1974. I went to LSU and graduated with a BS in accounting in 1978. Went straight into law school and graduated from LSU Law School in 1981. I went into private practice. I was in private practice for 15 years, 11 of those years as a sole practitioner. And 96, I was elected and took the bench in 97, and I've been a district court judge presiding over a criminal court docket since that time. I've had many opportunities to switch and take a civil docket. I haven't. I realize how important it is to have fair judges in criminal court because it really does affect people's lives and not just people in front of you, their mothers, fathers, sons, daughters, brothers, sisters. It affects a lot of people every time one person comes to district court. While I've been on the bench, I've handled over 200 jury trials. I think that's more than anybody else in the 19th JDC while I've been on the bench. I've handled 6 death penalty cases, including Derek Todd Lee. Uh, I like to keep my docket current. Sometimes lawyers like that, sometimes they don't. Defendants do, though. I know that because they know I won't tolerate unreasonable delays. I've tried to use a common sense approach both on the bench and in my life, and I find it goes a lot better if you try to use common sense. My philosophy is to apply the law to everyone and not to legislate from the bench. Back in 96, when I ran, I made promises to be fair to everyone, to protect the public safety, to be tough on violent criminals while giving nonviolent criminals an opportunity to rehabilitate and get their life on the right track, to protect victims' rights and to treat everyone with dignity and respect, to work hard, keep the docket current, to be accessible to attorneys, and to serve with honesty and integrity. As I said, those were the promises I made in '96. That's now not only the promises and the platform now, that is my record for almost 24 years. I've also demonstrated during that time that I had the judicial courage to do the right thing, even if it's not the popular thing to do or something that public opinion is against, because that's not the role of the judge. The judge is to do the right thing according to the law and the facts, and I've done that.
Okay, okay. Yes, sorry, I think we had a problem with the mute button, but thank you so much for telling us a little bit about yourself. Now, I do understand that you have been on the bench for a while. I believe you stated 24 years. What is your vision for the future of our judicial system, and what changes would you like to advocate for, and why?
All right, the main change I would like is for it to be a lot more efficient. And we've been doing some things to make it more efficient. We've tried to do things like speed up arraignments, and then COVID hit, and that threw everything in, tailspin. But even before we started doing the thing for a while for 72 hours arraignments that we were trying to get going. My policy's always been in my office. If we get a bill of information, it's filed. We set it for arraignment the next day, next court day, that is. And I think that's a system that works good. It just really upsets me to have somebody out there on a, let's say, a possession of marijuana or disturbing a peace charge, possession of marijuana under 14 grams. That's a maximum of 15 days. Well, if they're not brought to court, if for some reason they can't bond out, if they're sitting in jail for 30 days, that's twice what the maximum sentence is. Uh, I would like to use more electronic stuff. We're starting to, or have started using Zoom for prisoner arraignments and status conferences, and even a few motion hearings. We can't do it for our trials, of course, but we are trying to do that so nobody just sits out there and languishes in jail while we're trying to figure out the COVID thing. Um, what I would like to do, as I said, speed it up and make it more efficient, because it really upsets me when people are sitting out there and they're not, uh, they have not been adjudicated. They're innocent until proven guilty, but they're still sitting in jail.
Okay, thank you. My next question is, Louisiana has held the title of mass incarceration in the world. We in Louisiana today know that one in every three Black men will serve prison time. Do you believe it is part of the judge's ethical role to combat racial bias and discrimination in the criminal legal system?
I'm sorry, you broke up on the last part of that question. I heard about the, leading the nation or world in mass incarceration, but after that, I couldn't hear you.
Okay, so I'll state the question again. Sorry about that. Louisiana has held the title of mass incarceration. We in Louisiana today know that one in every three Black men will serve prison time. Do you believe it is part of the judge's ethical role to combat racial bias and discrimination in the criminal legal system?
It's a judge's role in court to be fair and impartial to everybody and make sure that they are treated fairly and impartially. So not only racial bias, but any kind of bias. It's our job to make sure that everybody is treated equally. And there are some things that probably show up more. One of the questions that I was just talking, or problems I was just talking about, people sitting in jail, they can't make a bond, and there are all kind of reasons for that. But and their case just sits there. They keep just languishing in parish prison while the judicial system moves at a snail's pace. Well, I don't like that, and what I've done is try to speed up the process. I try not to allow any unreasonable delays, This is what, when I said a while ago, some attorneys like that, or some of them like it some of the time, some don't like it other time. But I try to make them get their cases ready quicker so we can get it disposed of quicker. And there are so many people out in parish prison waiting for their day in court, and they come in and they end up pleading to a lesser charge, not because they are guilty, but because, or at least they don't feel they're guilty. And they tell me this when I do a Boykin examination, but because they're ready to get out of jail and they can plead to a misdemeanor and go home, or they can plead to a felony and get probation. But the problem is that conviction is with them from then on. And I don't care if, 894 or 893 allows it to come off their criminal history. From what I've been told, most job applications ask, have you ever been convicted of a crime? And if so, explain. So then you have the dilemma. Do I report that, even though they may or may not be able to find out? So, a lot of people end up pleading just to get out of jail, and they don't really realize all the long-term repercussions that's going to have with their life.
My next question is, what factors would you consider in setting bond amounts, and would be your primary consideration?
Well, the primary consideration is always the crime. And the reason I say that is some crimes you aren't allowed to give a sign out or a personal surety or an ROR. It has to be commercial surety or a property bond. So you always consider the crime first, but also consider the facts. And generally, all you have is the affidavit of probable cause. So you read that, but you have to realize that's generally one half of the story, because most of the time they don't have a statement from the defendant. Sometimes they do, and it kind of hurts the defendant, but uh, sometimes they make a statement and it makes sense. So you have to consider everything about the case. You have to consider the safety of the community, the safety of the victim, how likely are there to be any other repercussions with the victim if the defendant is out. Um, Criminal history, that's a big one. No judge ever likes to see somebody that has a bunch of arrests for the same charge. And one thing in particular is if they're out on bond for a same or similar charge, especially, you don't like to see that, and that goes up. But generally, I consider anything that may be relevant to the bond amount, the person showing up, the safety of the community. For example, even are they working? Are they in school? Are they in drug rehab? Or anything like that? Anything at all that reflects on the safety of the community, the person's probability of showing back up for court dates, and that's the main thing. And like I say, there's the strength of the evidence too, but that's one-sided generally.
Right. The next question that we have is, what injustices have you witnessed inside or outside of the courtroom, and what was your response to that event?
All right. Well, I've already mentioned some of them. Delaying a case that is a weak case, and back when I was practicing law, and even now too, when they delay a case forever, there's generally a reason. Somebody don't want to try it. Sometimes neither side wants to try it because they have either a weak case for the prosecution, or the defense thinks we're not going to win this case, so let's just delay it. Well, for the cases where it's a weak case for the prosecution and the defendant sits out there in jail, it makes it more right for them to come in and plead to a lesser charge and go home. And like I say, I hear that all the time. I just pled because I want to go home. And to me, that's an injustice for the reasons I explained a while ago. This goes with them forever and can cause some serious impact on their ability to get jobs or get into certain programs. Uh, and I don't like that. And I do what I can to speed it up and make sure that that doesn't happen on my watch.
Thank you. My next question we have is some states have made their specialty courts a pretrial diversion model. Here, the only specialty court we have in the 19th Judicial District Court is drug court, but people must plead guilty to receive services. Would you support a specialty court model where a person does not have to plead guilty in order to receive the necessary services to receive help?
Yes, and even though we don't have a specialty court for things, there's been talk about, setting up a veterans court, a domestic violence court, those kind of things. And even though we don't have a formal one set up, I don't know how all the other judges do, but when a defense attorney comes and tells me, well, this guy's a veteran, he's being treated for PTSD, he's being treated at the VA, and these are some of the problems he's having that are related to that, whether it's drugs or some other, domestic violence or stuff like that. We take that into consideration. Even though we don't have those courts, the defense attorney can bring forth that information to the court, and the court can always consider that stuff. It's true, we won't be bringing them in every month or every week to review that stuff, but we can set reviews as many times as we want. One of the good things about being a judge. But as I said, you can help people even though it's not in a specialty court. And I have treated or dealt with a lot of people with PTSD or same thing for domestic violence. Especially don't like the fact that they maybe in a specialty court would have to plead guilty because a lot of times in domestic violence, you really can't tell if they're guilty or not. You don't want to plead guilty just to go to the specialty court, and when you can send them to all that treatment, to the counseling, and we do that day in and day out, send them to the domestic violence offenders program, and that's while their case is pending. They haven't pled guilty, and then when they're matter of fact, it gives them more incentive to complete the program if they don't plead guilty, because a lot of times that's either at the end of it, the district attorney will dismiss the charges or let them plead to something less egregious. And um, a lot of times the victims are there, they don't want them to go to jail. They don't want them to have a conviction because a conviction is going to impact a lot of times the very victim of that case, their wife or significant other and their children. And so they're just wanting to work this problem out and get them back on the right track, get them back to work, providing for their family, but they don't want any more domestic violence either.
Thank you. The next question we have here is a little bit long, so I'm going to try to take my time and read it. The Code of Judicial Conduct in Louisiana to be requires to be impartial. The code defines impartiality as the absence of bias or prejudice. There is an ongoing conversation happening in the country around the issue of how to address bias. In response, states like California have recently made anti bias training mandatory for their judiciary as part of their continuing legal education. Do you believe that anti bias and implicit bias training should be a component of the obligation to continuing legal education for anyone who is serving as a judge?
You broke up right at the end, but I think you asked if I think that sort of training should be required. Did I hear that right?
I'll read the last part
Just the
again.
last part.
No, yes. We don't want to go through that long question again. Do you believe that anti-bias and implicit bias training should be a component of the obligation to continuing legal education of anyone who is serving as a judge?
Well, I don't have a problem with that being mandatory. We already have ethics that's mandatory. We have professionalism that's mandatory, and nobody can even explain what that is. So no, I don't have a problem with that being mandatory. And I've always felt like our continuing legal education should help us in the day-to-day operation of the court. And every judge should have those as goals, and to not have any bias at all, and definitely not let any bias have any effect on any proceeding in their court. Those are some of the goals that I shoot for. So no, I don't have a problem with that at all being mandatory.
Gotcha. And I do want to make sure I have the question right. I did say, should it be a component of the obligation? So would you have it? Would you have an issue with it being a? Would you support it being a component of the continuing legal education of the judiciary?
No, as a matter of fact, we didn't have judicial college this past summer because of COVID, but I do believe they've had some classes on that stuff already. So no, I don't have a problem with that being a component.
Thank you. Sorry about that confusion.
No problem.
Um, Of course, we always save our long questions to the end, clearly. So this is a little bit long, not as long as the last one, I promise. Judges are required to rule based on the law. That sometimes means they have to make decisions that are not popular in opinion. Can you talk about an experience that you have had in your personal or professional life where you have had to make an unpopular decision? What was it? How did you handle it? And would that decision make you a fair judge today?
Well, I've got several I think I could talk about, but I'll talk about one. The first one that came to mind a year or two ago, maybe 3 years now. There was a fellow by the name of Wilbert Jones. He had been in Angola for 47 years for aggravated rape, and that rape took place, I believe, in the 70s. I don't remember the exact date. Well, in his post conviction relief, and I think Project Innocence got involved in going through documents related to his case, they discovered that there were several things, Brady material, exculpatory evidence, that was not turned over to his defense team about another serial rapist at the same time, and matched the description the victim gave much better than Wilbur Jones. Wilbur Jones was about 5'6" or 5'7". The victim described this person as tall as her husband. Her husband was like 6'2" or 6 foot. I can't remember, but a big difference. And especially when you consider the facts of the case, she stood next to this guy for a fair amount of time. In any event, there were some other things. Wilbur Jones filed his post conviction relief, claiming they had turned that over and asking for his conviction to be thrown out and for him to be given a new trial. Well, it's kind of tough. The victim is now dead. Of course, they had her testimony, and they could use that. And of course, they had all the new information too. And I listened to all the facts that came out at the hearing. I looked at the law, and believe me, it's never a popular thing to throw out a conviction of a rapist. Okay, so I had to decide: is this the right thing to do? I didn't care about the public opinion. I knew what the right thing to do was, and I threw out that conviction. Also, then they tried to keep him in jail on a high bond while they had their 1 year to retry him. He was already in not the best health, but in any event, I said no. I'm going to give this man. They told me we've got $1,000 we can put up for the bond. I set his bond at $1,000. He never missed a court date, although there were only a couple. And then the district attorney ended up dismissing those charges, saying they said what they said, but they said they couldn't try the case again because all the witnesses were dead. And there were some other things. I had you may remember Henry Montgomery. It's a case from Baton Rouge. It went to the U.S. Supreme Court. It's a case dealing with not minorities, minors who were sentenced under an automatic life without parole sentence, and whether or not that was constitutional. The Supreme Court said that's not constitutional. That should be only used in rare cases for people who are basically beyond rehabilitation. Well, we had a hearing about whether or not Henry Montgomery should have the possibility of parole. And I found that he was, in fact, going to be sentenced with the possibility of parole. And that wasn't popular either, but anybody that heard the evidence about he's been in Angola, and by the way, his I think he was in jail 30 something years. Okay. So he had a really long record in Angola and he had hardly any blemishes on there. He was very much trusted. He had people from Angola coming and saying, we trust him outside of the gate. He's that much of a good person now. He's turned around and he didn't have a really bad record when this happened, but it was a murder. So I gave him that. There's always some repercussions, but as a judge, you just have to put all that aside. And many times, if it does cross your mind, or at least if it crosses mine, I got to think, this is exactly what I signed up for, to be fair to everybody. And therefore, you do what's right. If you can live with it, and I've always said, I'd rather get voted out of office for doing the right thing than reelected for doing the wrong thing. And that's not just something I've said now. That's something I said back in '97 on up to now. So, and there are a few other things like that. I've had waived jury trials for murder, and it was pretty high profile. After a rap concert, somebody gets killed, and long story short, they they prosecuted this guy, and the only evidence they had was one witness who testified at the grand jury that he saw this guy kill the victim. At the trial, though, he testified he didn't really see the trial, but that was the word on the street that this guy did it. But he didn't see and he really didn't know who did. Well, you can't send somebody to jail for the rest of their life on that evidence. So I found him not guilty. And, it's, you know, I think the right thing. By the way, I have checked ran his refuge since then, and he's been good since then. My main fear was, and he may have killed him. I don't know, but the state had not proved their case beyond a reasonable doubt then. So I had to find him not guilty, and that's my job, and I did it.
Oh, well, thank you so much. I see we're coming up on 6:28, so at this time, I'm going to give you a couple of minutes to be able to speak to the community and why they should vote for you before we transition into our next segment.
All right. Well, I appreciate again the opportunity to be here, and as far as why they should vote for me, you know what you get. I've been doing this for 24 years, and I would say that, and I think most people, that I have done what I promised. I've been fair to everyone. I have treated people with dignity and respect. I've been tough on violent criminals. I've given nonviolent offenders an opportunity, sometimes more than one, to rehabilitate themselves. I've protected victims' rights, protected the public safety. I've served with honesty and integrity, and I've been accessible to attorneys and just about anybody, you know. And I've always tried to work hard when I'm on duty. I set bonds generally at least every hour or two up till 11:30, 12 o'clock every night, and get up in the morning and check those too, because I don't want people sitting in jail that are presumed to be innocent. However, we do have to set a reasonable bond, but remember, they can't bond out until they are set a bond so that they'll know what to make. I have demonstrated the judicial courage, or that I have the judicial courage that it takes to be a really good judge. And uh, I've always uh, treated people fairly. And that the main purpose of a judge is to be fair to everyone and to make sure the proceedings are fair.
Okay. Well, look,
And
right on time.
I would appreciate your vote.
Well, thank you so much, Judge Anderson, for being here. And I state a big thank you from the NAACP and the Louis A. Martinet Legal Society both here in Baton Rouge. We know you could have been many other places, but for you to spend your time with us and also being able to speak to the community on why they should vote for you and also for them to get to know you a little bit better. So we're appreciative. We thank you. We hope you have a good rest of your night. And at this time, we're going to be transitioning into our next segment. But thank you so much.
Thank you.
Hey, can you hear me?
I can. I know we're live right now, just so we can give you all a warning. I
Oh,
So I understand it's 6:30. So we're gonna kind of just go ahead on and get started. I will introduce myself to the both of you. My name is Elena Booth. I am the Social Justice Chair here at the Baton Rouge branch of the NAACP. I bring you greetings from Mike McClanahan, our Louisiana State Conference President, and also greetings from Eugene Collins, our president here um, at our Baton Rouge branch. I also bring you greetings from also the Martinet Society right here in Baton Rouge, and Michael Victorian, who is president. We thank you so much for your time and spending the next hour with us. Hopefully, we'll have some fun. Hopefully, the community will get to know both of you a whole lot better and understand why, what voice that do they want there, right there in the bench, on the bench in Baton Rouge. We know judges have a lot of power. So thank you so much for spending some time with us. I'm going to give both of you just a few minutes, 5 minutes. Let me actually state the time to be able to introduce yourself, say who you are, what division you're running for, and just to tell a little bit about yourself. Then we're going to go into a series of questions. Each of you will get 2 to 3 minutes each to be able to answer your questions. We do ask to be able to respect that time limit just because we do want to make sure you both be able to have adequate time to be able to address hopefully a good bit of questions we have here. We also will give you a few minutes at the end for you to be able to tell the community why they should vote for you. And hopefully we will go ahead on and get this thing started, right? I am going to have Attorney Lawrence be able to go first, and we'll kind of go from there. And actually, I will actually let ladies go first. So, Attorney Rose, I don't know if you want to me to call you Attorney Johnson or Rose. Please let me know because I want to be respectful of that. But I'm going to go ahead on and give you 5 minutes to be able to tell you a little bit about yourself.
well, thank you again for having me. And my name is Ebony Johnson Rose. I'm running for the District Court Judge, Division K. That is the seat that is currently being held by the Honorable Bonnie Jackson. She has served on the bench in this capacity, on the criminal bench for the past 28 years, and we commend her service. A little bit about myself. I'm a mom. I have 2 sons and 2 twin daughters from my marriage to Jonathan Rose. We've been married 5 years. And I'm a graduate. I'm actually a 2-time graduate of Southern University, the Southern University. Graduated in undergrad in 2000 and received my BS. My bachelor's of arts degree in political science. I then went to law school and I graduated in 2005. I was number 5 in my graduating class. I graduated magna cum laude. And I've been practicing law here in Baton Rouge for the past 16 years. You know, I passed the bar the first time, so I thank God for that. I've had a wonderful time living here in Baton Rouge. I moved here in 1998 to continue my studies at Southern. I'm originally from Houma, Louisiana, which is a small town in Terrebonne Parish. I'm a country girl. So I grew up outside doing a whole lot of outside things, but I've been here in Baton Rouge since then. My father's family is from Baton Rouge. They grew up in the park. My dad, Ron, and his brothers and sisters all attended high school here and went on to college here. In my career, I've handled tons and tons of civil cases. I'm actually licensed in all courts in the state of Louisiana, as well as the federal courts. And so I've actually had a very active practice all over the state, working for the state of Louisiana with 4 different state departments. I've worked for 3 law firms handling major civil litigation cases, and I've actually tried cases in the federal court. I've actually been all the way to the Supreme Court. So I think that I have the right temperament, the right disposition, a heart, and the compassion that is needed, and also the strength and courage that is going to take for a judge to make right and sound rulings. So that's about me. Thanks.
Thank you. Thank you. Attorney Lawrence, you also have 5 minutes to tell the community a little bit about yourself.
All right, good evening. My name is Quintillis Lawrence, and I too am running for Division K of the 19th Judicial District Court. This is the seat, as Ms. Johnson-Rose indicated, that Judge Bonnie Jackson has been presiding over for about 28 years, and she is retiring. So it is going to be a vacant seat come January 1 when the new judge fills that term. I'm running because as I sat as a commissioner on that court and learned of Judge Jackson's retirement or pending retirement, I looked around and I said to myself, what can I do that brings to this court a different approach, a different perspective? And as a member of the United States Army Reserve for 29 years, serving as a judge advocate, practicing in the courts, Marine courts, Army courts, advising generals, advising colonels. I know that I have a temperament. I've experienced the court as a judicial officer, experiencing what my temperament would be. And I said to myself, asked my wife, asked my children, prayed about it, and we decided that this was something that we could do and should do so that the community has the best and the brightest on the bench to make sure that justice is served in the most compassionate and passionate manner as possible. I am a graduate of Southern University at New Orleans. I graduated with a degree in political science in 1998. I graduated from Southern University Law Center in 2001. I was moot court board chairman when I graduated. I'm again a member of the United States Army Reserve, 29-year veteran. I am a member of the Louisiana Law Institute. I got the opportunity to help make the law, help shape the law. This is the arm of the legislature that looks at the law and determines what changes needs to be made based on their recommendations. I also teach at Southern University Law Center now. I've been doing that for about 4 years now, teaching criminal law, criminal procedure, and evidence and torts of all things. I think that my experience, my diverse experience, gives me the best opportunity to come to the bench and not have the, okay, what do I do now and how do I do this? Because I practice as a prosecutor, a defense attorney in the courts, having those motions, having those hearings, having those trials, jury and bench trials, wherein I've had to deal with the same things that I'm now teaching, I'll be in a position to rule on. So I'm running because I'm fit, I'm ready, and I'm capable to do this job and to do it well for our community.
Thank you, Attorney Lawrence. So at this time, we're going to start our series of questions. As I stated before, we're going to give each of you 2 to 3 minutes to be able to answer it. We will also switch back and forth on actually who goes first. So please forgive me if for some reason I forget and the other person goes first mistakenly twice. We're going to start here with the first question. Please let me know if I need to repeat the question when it's your turn. What is your vision for the future of our judicial system, and what changes would you advocate for and why? Attorney Lawrence, I'm actually going to let you go first this time.
Okay. One of the things that I look forward to doing when elected to the bench is opening up a veterans court. Veterans courts are essential in a state like Louisiana's, especially where we have a number of veterans throughout the state. We have Fort Polk, we have Air Force Base up in Shreveport, we have numerous military and National Guards installations across this area. and specifically large ones at that. My unit is a Colonel Command out on the Innovation Park Drive. And there are many veterans who come back from serving our country, ensuring that we can have this system that we serve in and benefit from, and they end up self-medicating. They end up having issues that they don't get treatment for. And the Veterans Court is an opportunity to ensure that those individuals who make sure that we have the freedoms and rights that we have can have a second, sometimes a third, and maybe even a fourth chance at freedom, and at having a blemish not be placed on their record. So that's something that I'm looking forward to doing for our court, in addition to ensuring that there are alternative sentencing provisions that are placed, because in a state that has the highest incarceration rate, we dropped below Oregon, and then we rose right back up, and Oklahoma, and then we rose right back up. That is not what we need to have. We need to stem the prison pipeline, and we need to ensure that we look at giving people opportunities and partnering with organizations that will do the same thing, help these young men and women, older men and women, get some places that they can do things that will help progress their lives and propel themselves to higher heights, as opposed to pushing them in the prisons.
Thank you. Same question, Attorney Johnson Rose.
So the question was, what was my vision for the judicial system and what changes would I advocate for? So first and foremost, we have to do something with our pipeline to prison. Louisiana is the state that has the highest number of incarcerated persons in the world. And I didn't say the United States, I said the world. We are in the business of putting people in prison. So the very first thing that I want to do is to establish a program for first time or for nonviolent offenders, so that these young people, or however old that they are, if they haven't obtained their GED or their high school diploma, that we would actually put them in a program so that they could obtain their GED. And if they have graduated, we would partner with the technical college or one of the Baton Rouge community colleges so that they can get a trade. I believe that if we empower our people economically, that we can lessen the crime rate. And another thing is, we have so many people go to prison. So many people in this state. And so I want to have alternatives to incarceration. And that means bringing in specialty courts. And the main specialty court that I would like to institute is a domestic violence court. Right now, domestic violence is heard in our family court. And they have 4 judges that hear those cases on a daily basis. But then if we also have persons that are being heard at the night criminal matter. And so I think combine resources that effectively be able to treat the people that actually are abusing, because that's the component that we lack, is treatment. And then we can also have everything in one place where victims can get the resources that they need. So those are the things that I plan to implement. And also, just quickly, I do want to add that our misdemeanor cases are not being heard in a timely manner. So I do want to implement a 90-day program where all misdemeanor charges are heard within 90 days and disposed of.
Okay, thank you, Attorney Johnson Rose. I also want to just state, I don't know if there's any way your internet connection, you did come through a little bit choppy. I think for the most part we were able to hear your answer, but I did want to let you know, because I don't know if there's something that maybe you can mess with your internet connection, but I did want to kind of give you that heads up. So I think you all kind of jumped to specialty court. So let's go there. Judges are required. Okay, wait, I'm sorry. I have to now jump to that next question. Give me 1 second. Here we go. I'm sorry. I just wanted to make sure, since you all jumped to that question, I might as well go there. So y'all had an order, but I love it. Some states have made their specialty courts a pretrial diversion model. Here, the only specialty court we have in the 19 JDC is drug court. but people must plead guilty to receive services. Would you support a specialty court model where a person does not have to plead guilty in order to receive services? Attorney Johnson Rose, I believe you are first up, even though I think both of you have answered if you all support a specialty court.
Yes, actually, I do support specialty courts because we have the presumption of innocence. So a person doesn't necessarily need to have to plead guilty, especially if they have not committed a crime. We need to be able to have an alternative to incarceration. So having the specialty courts, like Mr. Lawrence said, for veterans, or like I have advocated for domestic abuse, I think it's going to be crucial to having people heard quicker and having their cases disposed of in a timely manner. And so this way we cannot bog down the court system. People can get back onto their lives, and then those that need to be incarcerated, then of course those people will go through the normal processes of having a trial and having that trial adjudicated. But yes, I am all for specialty courts where a person does not necessarily have to plead guilty in order to have their matter disposed.
Thank you. Attorney Lawrence, same question.
Yes, ma'am. I am 100% in favor of a specialty court that allows individuals to not plead before taking advantage of the programs. The unfortunate thing is that we would need to get the legislature on board to ensure that we draft something to ensure that that occurs. I'm more concerned with programs that require individuals to do onerous things in order to get the treatment necessary in the specialty court. Not that individuals don't need to do something, but these onerous timeframes, 2 years, it's almost like setting people up for failure. I like things like the Back on Track program that Vice Presidential candidate Kamala Harris had in California. It was a reentry program, but it allowed individuals to stay out of jail as opposed to going to prison for a reentry program, get job training, programs that allowed them to get their life back on track. And then at the end, it required them to plead, but it was set aside just as our specialty courts here would set it aside. But we have to do something more than just say, I'm going to put you in this specialty court, and if you make it, then you get to get the benefit. I think that you take the carrot approach as opposed to the stick approach. And that's what pleading guilty and saying, hey, I'm going to bring it all. I'm going to do away with the conviction in the end if you complete it, as opposed to, hey, you don't have to plead, but you can take care of these matters. You can get this program. You can get this treatment. You can do these things, and then you'll never have to plead, and we'll dismiss it. I'm 100% in favor of that.
Thank you. As you all continue to guide my questions, I heard you all both state about mass incarceration. Louisiana has held the title of mass incarceration in the world. We in Louisiana today know that 1 in every 3 Black men will serve prison time. Do you believe it is part of the judge's ethical role to combat racial bias and discrimination in the criminal legal system? I believe Attorney Lawrence is your turn to go first.
Yes, to the extent that, first of all, when we take the bench, we take it, we put on the black robe, which means that we don't see color, we don't see age, we don't see race. We hear the evidence and we apply the law to get an outcome, a just outcome. That's what we're supposed to do. But most people, because we're human, we see things. We see the man who comes before us. We see the woman who comes before us. We see the color. We see the gender. We see everything, the age. We see that. So we have to take an opportunity to check ourselves. We have to check our biases. We have to check ourselves to ensure that we're not doing this because, and I'm talking about myself and everyone else, Black, white, old, young, male, female, doesn't matter what the judge's biographical sketch is. Each and every one of us must check our biases to ensure that we're not making a decision based on who we have in front of us. We make the decision based on what we have in front of us in terms of the facts and the law is applied to them. Now, that does not mean that a judge should not look and consider the whole person, because that's exactly what a judge should do. A person who has had, shall I say, a tough way to go, well, that person may have been found him or herself in this situation before that judge because of that tough way to go. And other than that, they would have been what we would call a fine, upstanding citizen. So we have to make our decisions and we have to factor that in. But I do not believe that we should avoid telling judges, requiring judges to get some programs in place to make sure that they check their biases, because we all have them.
Sorry. At this time, Attorney Johnson Rose.
So yes, absolutely. We definitely all have biases. We have prejudices because we're all human. And just because we put on a robe, we do not, like I used to say, disrobe from being human, because we bring our backgrounds, we bring our life's stories, you know, our upbringings. And so I think that it is incumbent upon all judges to not only check themselves and realize and confront the issues that we all have within ourselves. We tend to, you know, want to mask it and hide behind all kinds of things, but we really need to take and do some self-reflection. But we also need to hold our other counterparts accountable and call them out when we see that they are being unfair to one group of people, not just because of their skin color. Maybe it's because of their age. Maybe it's because of their sexual orientation, or whether they're a woman or a man. And so we also, I think it's incumbent upon us all to take some type of classes so that we can check ourselves and present our best front, and always look at the situation and judge the person based upon the crime that they were accused of committing, but also being mindful of this person's life story, because we all do things that are out of character sometime. And so I think that is an incumbent upon us as people to check our biases at the door.
Thank you. I guess I just won't worry about my question on implicit bias. I mean, you all are just y'all are getting me. So let's like switch all the way gears. So hopefully you all won't control my questions on this one. At this time, I'm asking, who are your judicial role models, if any? Attorney Johnson Rose, I believe you are first up.
Well, first and foremost, the person that has played the role in my life as a judicial advisor is my uncle Don Johnson, who has served in both the civil criminal bench at the 19th Judicial District Court, as well as serving for 6 years on the city court bench. He's been my role model. He stands for his principles. He's a very principled man, and he has taught me to always do the right thing regardless of the situation. He is a pillar of a strong person, and I think it takes courage to be on the bench, and he's exemplified that throughout his time on the bench. He started so many different programs at the 19th Judicial District Court, as well as on the city court. He gives back to the community. And I think that it's important that our young people are able to see strong Black men and Black women who are in a position of power, but never forget where they came from, and are always willing to go back and be of service to those that they serve in the community. So he has been my beacon. He has been my pillar, and he has been my role model. And I thank him for his time on the bench and his service to the community.
Attorney Lawrence.
Yes, ma'am. Aside from the obvious in former Supreme Court Justice Thurgood Marshall, my role model is a man by the name of Judge Earl Glanville. This is a man who served in the United States Army for some 30 some odd years. He achieved the rank of Brigadier General, and he impressed upon me the idea that one, you have to continue to educate yourself in all areas, not just the area in which you're comfortable in. And that would, for me, would be criminal law. I read things on criminal law, and he taught me you have to expand your horizon. You have to make sure that not only is it the thing that you're most comfortable in, but the thing that makes you uncomfortable. And for him, it was not just the law, because we both served in the United States Army. He taught me, look at the things that your client, the Army, has to do. Learn that. Make yourself an asset to them. Because when you have to advise them, you have to ensure that you know what it is that they're going through in terms of what you're giving them advice on. And as a judge, he, similar to myself, I have patterned my career and my career path and goals after him. He served as they call them magistrate judges in Atlanta, a magistrate judge appointed by the court. And then he was elected as a judge, but he also served as the chief of the Criminal Court of Appeals, the Army Criminal Court of Appeals, as a brigadier general. He sacrificed his time on the bench in Atlanta so as he could serve our country as a judge on the bench in Virginia or wherever the court would meet, because the court also meets at different jurisdictions across the country so as to give law students and lawyers who don't get the opportunity to see a military court system in action see that. He has been my role model in that he has basically given me, shall I say, the roadmap to success, not just as a judge, but as a man. And I appreciate him for that.
Thank you so much. My next question is, the COVID crisis caused court systems nationwide to pivot and proceed in new ways. What methods do you have in mind for improving court procedures and efficiency within the 19 JDC? What other methods would you suggest? Attorney Lawrence, I believe you are first.
Yes, ma'am. Well, I think that we have been forced to be technologically more advanced than we were on March 16th, I think it was, because I think it was the 17th when we halted all proceedings because of COVID. I think that the technology that we're using ought to be expanded and continued for certain things. I think that we need to ensure that we make those things quasi-permanent, on some of them permanent. The fact that when we look at TV, we see in Florida, every time an individual, they have the man from Florida did this because it's the running joke, but that individual is always being arraigned from a remote location. We can continue to do that so as to ensure that the dockets are more expedient. We can continue and ensure that we do a more perfect docket, if you will, by not putting things on the docket just to put them on the docket, wasting time. We can move cases without just setting statuses just for the sake of setting statuses. Civil dockets move expeditiously because they do case management orders. They ensure that they have a layout as to how things are going to go from the beginning, pretty much. Now, yes, in the criminal docket, it is different because that's where your rights come in, and you don't want to ever impose any restrictions on an individual's rights. But there is a way to utilize case management orders and things of that nature to ensure that you follow what the Code of Criminal Procedure has already laid out. So I think that if we follow the Code of Criminal Procedure, institute some of these technological ideas, we'll be able to move forward with staying up with the rest of the country and stay in the 21st century.
Thank you. Attorney Johnson Rose.
Yes. So unfortunately, well, let me not say unfortunately, I would actually say fortunately for us, COVID happened, and it happened at a pivotal time within the 19 Judicial District Court. We have one of the slowest courts in terms of cases being disposed of, because for some reason, our cases are just not being heard in a timely fashion. And so I welcome the technological advances that the 19th Judicial District has imposed. And I would ask that they actually do more, go further than what we've gone. We need to have instituted online filings. Federal court, it's been that way for years. And I don't know why we haven't instituted the same type of practices here at the 19th Judicial District Court, but I think we need to move to a completely online system. And then that will help us in a great way in terms of disposing of cases. Also, we don't have any type of case management. If you've practiced at all in family court, you are given a case management schedule. You are given deadlines. The same thing in our civil process. But it's not like that in our criminal district court. And we need to institute deadlines. We need to have a case management schedule that all judges should follow, because right now, every judge is autonomous. They do what they want to do in their courts. And if we need to institute uniformity throughout our criminal district court. Misdemeanors need to be disposed of within 90 days. There is a method out there that we can utilize here. And all our felony cases can be tried within a 2 to 3 year period if the judges are going to get together and agree to set these deadlines. I think that it would bode well for lessening the docket and having cases heard. And so I would just like to add that I think if we move more to a federal process in terms of handling our cases, that we can unload our dockets.
Thank you. So my next question is what factors would you consider in setting bond amounts, and what would be your primary consideration? Attorney Johnson Rose.
I'm sorry, I was writing your question down. So the factors to bond amount. So first of all, we have constitutional provisions, constitutional and statutory provisions that dictate our bonds. The bottom line is the bond is only set so that we can ensure that the person that has been accused of the crime comes to court. We want that person to attend all of their court hearings. But bond should not be a penalty. There is a presumption of innocence embedded in our Constitution that we do not follow. Bonds are set so extraordinarily high as to penalize the poor, those that do not have the economic means to post their bonds. So one of the paramount considerations has to be, is this person a threat? Are they a risk to society? What is their economic status? These are the type of factors that we need to look at in terms of setting bond, because it doesn't necessarily have to be a monetary bond. Our state can, working with the legislature, I think that we can eliminate the cash bond system because it is a penalty. And so when you have poor individuals that may not have even committed a serious crime, but they're getting a $50,000 bond, they're having to sit in jail. And I just do not think that that's right. There have to be other things that we can do to lessen the load that we're putting on people. There is a presumption of innocence.
Attorney Lawrence.
Yes. The factors that I would consider, in addition to the amount of evidence that is presented at that first appearance, the criminal history, the risk to the community, flight risk, severity of the offense, are what is this person's familial background? What is his or her work history? Are they working? Because people are sitting in jail because they can't make the exorbitant amounts of bonds that are being set. I made sure that those people who were in jail, who weren't able to make those bonds, that at least a few of them were in a position to be bonded out. That's why I brought the bail project here. Jill Steinberg's organization that she started in the Bronx DA. She was on a TED Talk. I saw her, I reached out, we made the connection, they came, and they're here because of my efforts to ensure that if people are going to sit in jail because judges are reluctant to be courageous enough to say, you know what, this person here charged with this misdemeanor, should get an ROR, because that does exist. It is a part of the code of evidence the code of criminal procedure that is allowable, an ROR. But it seems to be something that's unheard of here in the 19th JDC. Other courts, they do it because they know this person's coming back to jail. This is a misdemeanor, or this is a low-grade felony. They're not going to disappear. And if they do, they got other issues that they got to deal with. So why not let some of these people out on their own recognizance? In the end, if they don't show up, they're the ones responsible for that amount of the bond. So I don't see the problem with allowing RORs on a lot of the cases where people are being arrested for these low-grade felonies and these misdemeanors. So that's the first thing that I would do, is I would be cognizant of the fact that it exists and we can utilize it. So, and I'm not afraid to utilize it. Now, of course, if the individual doesn't do what they're supposed to do, then they've penalized themselves by putting themselves in a position to say, okay, your flight risk is high because you haven't come to court. You were given an opportunity to be out, to go back to work, to go back with your family, and you didn't come to court on multiple occasions, on one occasion, or whatever the case may be. But those are the things that I would consider: the constitutional provided provisions and their familial history, their work history, and also whether or not an ROR is appropriate.
Thank you. The next question we have is, to what extent have you practiced civil and criminal law? What type of trials have you participated in? And what was your most challenging? Attorney Lawrence.
I've practiced a vast majority of my career in the criminal arena. I was an assistant district attorney for 3 years in New Orleans. In dog years, it's a long time because New Orleans, it's an everyday thing. And I practiced as a public defender for a total of 7 years, all criminal. In addition to that, I've practiced as a private practitioner as a public defender. I had my own practice, and I practiced some civil stuff. I did some stuff with sex abuse. I was with a lawyer out of Texas doing some pro hac vice stuff, dealing with the Catholic Church sex abuse scandals. I dealt with some collections work and things of that nature. But my most challenging, I've had jury trials, I've had bench trials, the gamut. My most challenging was a murder trial. I've had multiple murder trials. The most challenging was a gentleman who was charged with manslaughter, and all of the evidence pointed to self-defense, 100% self-defense. He was being beaten, and he ended up protecting himself, and the individual that he protected himself died as a result of the wounds that were inflicted. And myself, my co-counsel, it was definitely self-defense, but he ended up being convicted by the jury. And that was challenging because you get clients who are either innocent or not guilty of what they're charged with. And because it's the people, the jurors, who have to make those decisions in terms of guilty or not guilty, it's heart aching to have someone be charged with something when you feel that they are totally innocent. It's easier when an individual is just saying, hey, yeah, I just don't want to take the time that they're offering, so let's go to trial. But it's hard when you have someone that you feel is innocent. So that was my most challenging.
Thank you. Attorney Johnson-Rose.
So over the last 16 years, probably the entire time, I've had a civil practice. When I graduated from law school, I did work for 3 law firms, and I did major civil litigation work. So I have had bench trials and jury trials in civil work. I've done toxic tort litigation throughout the state of Louisiana. I've handled huge projects for the state of Louisiana, especially when I worked for the Department of Transportation. I am the only attorney licensed in the state of Louisiana to do the first public-private partnership major highway infrastructure project. So I've had a lot of civil experience all throughout the state in administrative capacities, and I've also had trials before the federal bench. I've had a very limited practice in criminal court. But I don't think that that is a disadvantage going to the bench because I won't be trying any cases. I'll be sitting on the other side. So all of the necessary experiences that I've garnered over these last 16 years on the civil side will easily transfer to the criminal bench. The most challenging case that I've ever had, I was a young attorney and I worked on the Angola 3 case. Those were the 3 gentlemen that had received life sentences in Angola for murdering a security officer, and they were all on death row. And I was actually representing the Department of Corrections. But after having gone to Angola for 2 weeks, I interviewed these men. I sat down with them. We looked at the prison conditions and I read all of the transcripts from their original trials. And it was clear to me that those men had not actually committed the crime, but they were all on death row. And they were, sitting in this 5x8 cell for 23 hours out of every day. And it was a conflict within myself, knowing that I was representing the very agency that was keeping them locked up. And so when Mr. Woodfox was released a few years ago, I had an opportunity to meet him. And I apologized to him for working on the other side. But I also thank God that he was actually able to get released. But we have a job to do, and sometimes we don't like that job. Sometimes that job goes against our own convictions, but we're hired to do a job. And so at the end of the day, I had enough strength to know that my client in that instance was the Department of Corrections. And so although I had an internal conflict, I still had to do my job.
Thank you. My next question is, other than incarceration, what alternative means, if any, do you have in mind for addressing crime? Attorney Johnson Rose.
Okay, alternatives to incarceration. That is one thing that I have focused on throughout this campaign. So what am I prepared to do so that young men and women, or those persons that do not commit violent, heinous offenses, have instead of jail time? First of all, we have a lot of projects throughout this city. The very first thing that I want to do is implement a community-wide service program where we partner, where the court partners with local community organizations, so that the people that are being accused of committing crimes, that they're going to go back and they're going to service those communities. Secondly, I believe that if we give people an opportunity to educate themselves, that they'll have economic empowerment. So I want to have a program. Like I said earlier, if you are a nonviolent offender, I want to institute a program that if you haven't graduated from high school, you will receive your GED. If you have graduated, I want to have a program installed where these people can get a technical degree. I really believe that if we empower people economically, that we will have a lower crime rate. And secondly, I want there to be a domestic violence court so that the abusers are getting the necessary treatment and the victims are getting the necessary counseling, as well as their children.
Thank you. Attorney Lawrence.
Yes, I've already expressed how I feel as it relates to our veterans. And I think that specialty court would be a phenomenal opportunity to be an alternative to any type of incarceration for them. I think also we need to look at mental health courts, opportunities to say these individuals are not at the level that Louisiana says is the threshold for them to be found not guilty by reason of insanity or to not be held responsible for their actions. But there are definite issues with their mental health. And because of that, that's why they ended up in this situation. So we need to address the mental health issues for some of the individuals who come before our courts. In addition to that, those young individuals who come through from the schools, because we still have a prisoner pipeline. And unfortunately, we as the judges will not be able to stop it per se. It has to stop from the beginning at those individuals who are arresting them. So we need to stop putting police officers in the school and start putting social workers in the school. But that's beside the point. In order to ensure that those individuals have an opportunity, there are organizations that are out there right now that are not being utilized to their fullest potential. Organizations that some of us don't even know about. But I ran into some gentlemen during the campaign that talked about they were former incarcerated individuals. And it's their objective to ensure that these young men, they're focusing on young men, that these young men realize that the mistakes that they made were mistakes, and they don't want them to make those same mistakes. And they have a goal to ensure that they see what's going on in the community, that they put them to work in their various organizations, their various places of employment, to see what it is to be a young man of character, to get up in the morning, go to work, earn a living, and be respectful in your society and community. So we need to partner with those organizations adjudication to ensure that they get an eye towards success as opposed to an eye towards incarceration.
Thank you. The next question I have is, judges are required to rule based on the law. That sometimes means that you have to make decisions that are not popular opinion. Can you talk about an experience that you have had in your personal and professional life where you have had to make an unpopular decision? What was it? How did you handle it? Would the decision make you a fair judge today? Attorney Lawrence.
Well, living off of the quote that's been quoted a lot in my opinion this year, with various Zoom and live stream presentations. Thurgood Marshall said, "Do what's right and let the law catch up." Do what's right and let the law catch up. That's how I look at things as it relates to some of the issues that judges, lawyers, whether they're prosecutors, defense attorneys, civil attorneys, you have to do what's right and let the law catch up. I had a client who he was not innocent, and I had to defend him and defend him vigorously. What happened was, the individual was alleged to have committed a robbery and was armed. I mean, had made no bones about it that he'd done it, but just didn't want to go to jail. Was in jail, but didn't want to do time, if you will. Well, I had to fight and fight because the prosecutor wasn't able to get the witness there. Now, and I'm talking about someone who was alleged to have fired a gun at someone, took that person's money, and anybody could have been in the way of those bullets. But I had to ensure that if the victim wasn't there, the alleged victim wasn't there, that this case was dismissed. And we're talking about putting somebody on the streets who is dangerous. I mean, currently dangerous. Just dangerous. But I did it because that's my job. I had to say, Judge, you've given them 3 opportunities to get this witness here. They're not coming. I'm asking for a dismissal, or make them go to trial today. And that's what happened. So this individual was released, put back on the streets, the same streets that my family live on, the same streets that your families live on. But he was put on the streets because I did my job and got the case dismissed. And that was tough. It was tough, but it was something that I would do today. I used to tell people when I got deployed, I say, look, if I had to represent Saddam Hussein in the American judicial system, I would, because we have a code that we live by. You're innocent until proven guilty, and you have the right to have counsel. So that's what I had to deal with in that case, and I would do it again today.
Thank you. My next question is, what injustices have you witnessed? Wait, I'm sorry. I don't believe I had Attorney Johnson Rose answer that question. I am so sorry. I'm Attorney Johnson Rose. Can you please answer? You all, I have to keep up with the questions, and you all kind of bounced around so much. I'm sorry. I'm just trying to make sure I stay for Attorney Johnson Rose. I apologize. Can you please answer the question?
Yes, not a problem. It's okay. It's been a long night. Well, and I actually alluded to this earlier when I spoke of the Angola 3 case that I was involved with very early on in my career. And at the end of the day, we are all faced with decisions. And so my job was to represent the Department of Corrections, to advocate for those 3 individuals to remain incarcerated. And it was very difficult for me knowing that after visiting Angola, and trust me, that is an experience all within itself, to actually go onto the grounds and to visit the camps, to visit death row, to see men being in prison, in a very small confined space. And I read through all of those transcripts. And it was a ton of transcripts that we had to read through. And I had to interview the deputies that were there at the time. And it was very concerning to me, after having read all of that information, that these men really just did not commit this crime. But I had to fight to keep them in solitary confinement. And that was really tough for me, especially being such a young attorney. But I knew the oath that I had taken when I was sworn into the bar. And I knew that I had to represent my client. And my client just happened to be the Department of Corrections. And on a personal level, and a lot of people don't know this about me, but as a teenager, I was raped. And so my family and I had a very difficult decision to make when it came to whether I would keep the child that had been conceived out of that rape. And after much prayer, we decided that it was the best thing for me to give birth, which I did. And I can honestly say that it was probably the best decision, although it was the most difficult decision I've ever made in my life. It was the best decision because I now have a 27-year-old, very handsome, smart, intelligent son that I am super proud of. And so even when we have difficult decisions to make, if we just stand on what's right at the end of the day, I think that the Lord will guide us into making the right decisions.
Well, thank you. And thank you for sharing. That's an extremely brave moment. So thank you for sharing that with us in the community. The next question I have is, you all made it extremely hard on me, but in the most amazing way. Um, Actually, I'm seeing it's 7:23, so I think at this point I kind of need to wrap up. I believe at this point I am going to give each of you a few minutes. I'm going to actually start this time off with Attorney Lawrence. You're going to have about 2 to 3 minutes to be able to tell the community and everyone who's watching um, why to vote for you. Again, what division you're running for. And after that, we'll wrap up and hopefully thank the community for watching. So at this time, Attorney Lawrence.
Yes, thank you, Ms. Booth. I am Quintillis Lawrence again, and I am running for the 19th Judicial District Court, Division K, and I would like your vote because I am the best candidate for the job. Why am I the best candidate for the job? Because I have the breadth of experience and the nature to be the next judge on that court. I have served as a prosecutor. I've served as a defense attorney. I've served the country as a member of the United States Army, deployed in 2002 to Iraq, fighting to ensure that we can have a court, fighting to ensure that we have the rights that we have today as citizens. I am a professor of law. I am an administrator of law. I served on the court as a commissioner for 6 years. I have developed a temperament based on the breadth of my experience to be your next judge. I sit on the board of the Louisiana Law Institute, helping to shape the law for the legislature to vote on and argue to determine what is our next set of rules, what is our next set of laws when asked to. I have touched the law in every area that there is to touch it. I've taught it, I've helped make it, I've administered it as a judicial officer, as a commissioner, and I've practiced it. I've practiced it for the past 18 years, and I've practiced it in the United States Army, and I'm prepared to be your next judge. You will not have to worry about whether or not I'm asking, what do I do now? What happens here? Because I've been there and I've done it, and I'm prepared to go day one to be your next judge. So number 76 is your choice, the clear choice for your next judge on the 19th JDC Division K. And I thank you for your time to the NAACP and the Martinet Society.
Thank you, Attorney Johnson Rose.
So everyone, thank you all for joining in tonight. And I want to thank my members, the members that I'm a part of with the Louis A. Martinet Legal Society, as well as the local chapter of the NAACP for hosting tonight's candidates forum. I think that it is incumbent upon all of these organizations to try to educate our populace on the candidates that are standing for election to the various courts. And I am a candidate for District Court Judge Division K, the seat that is currently held by the Honorable Bonnie Jackson. My name is Ebony Johnson Rose, and I'm number 75 on your ballot. Why am I the best choice? First of all, I'm from this area. My family has lived in the Baton Rouge area their entire lives. I've spent my childhood here. I know the area. I know the people, because I am the people. I've lived in the 70805 zip code as long as I can remember. We own several properties in that area, so I am very familiar. All of my family grew up here. Not only do I have the community ties, I also have the sound legal experience. I have practiced law as a trial attorney for 16 years. I have worked almost in every court in this state for one or another state agency, representing the Department of Education, the Department of Children and Family Services, the Department of Transportation and Development, as well as the Division of Administration. I've worked for 3 major law firms, so I have the necessary experience to be a judge, but I also have compassion. I have a heart because I have 2 sons and I have a husband. And so I am all familiar with the difficulties and life challenges that are presented to Black men in this area. I have the temperament, I have the courage, but I also have what we all need, is mercy. We all need to walk humbly with our God and to give mercy when mercy is due. I will be fair, but I will also be just. I will make sure that justice comes and flows through my courtroom. So I'm asking all of you who are listening tonight that when you go to vote on November 3rd, that you vote for Ebony Johnson Rose, because she will make sure that you are treated with dignity and with respect, and that you receive justice at the end of the day. Thank you.
Thank you so much. And thank you, Attorney Johnson and Rose and Attorney Lawrence, for being here with us tonight. I know you all could have been many other places. I understand that it's 7:30 at night. So for you all to spend your time with us and with the community and educating the community about who you are and what you represent and what you stand for, we truly appreciate it. I'm saying that thank you from the NAACP and the Louis A. Martinet Society. We truly appreciate you all spending your time here with us tonight. At this time, I will also thank the community for every single person who is watching, who decided that they wanted to watch to assure that they were educated and informed voter. We hope that you all learned a whole lot tonight about several candidates. I see the thank yous coming in. We truly appreciate you all also for spending your time with us tonight. I am so happy to have actually been the moderator tonight. You all have filled my cup if you didn't fill anybody else's cup. I'm extremely excited about the future of the judiciary. I'm extremely excited to see the future and how the community is going to be pushed forward in such an amazing way. Thank you everyone for watching. I hope you both have an amazing night. And I hope everyone watching also has an amazing night. Hopefully you will be seeing some of us soon. Thank you.